Hello and thank you for joining today. Today's webinar is an insolvency webinar and forms part of our junior programme series. Poppy and I are going to be looking at two areas that commonly come up in our practices, that is the joyous issues of adjournments and costs. Poppy Rimington-Pounder joined Chambers last year and enjoys a busy practice across all areas that Chambers specialises in. My name's Katie Longstaff and I am a junior member of Chambers and I do commercial and insolvency work. Poppy's going to look at insolvency practitioners' liability for litigation costs, and then I'm going to be looking at adjournments of bankruptcy petitions, and I'll address some recent case law as I do that. So over to you, Poppy.
Thanks, Katie. So I'm just going to share my screen quickly, and then we can get started. I'm going to be talking about litigation costs for office holders. The focus of my talk today is going to be first on the general rules on the recovery of litigation costs for office holders. And then I'm going to look more closely at a case from earlier this year called Nimat Halal Food Limited and Patel. The issue in that case was, when will an office holder be held personally liable for the costs of a creditor's successful appeal against the rejection of their proof of debt under Rule 14.9 of the Insolvency Rules. In that case, Judge Briggs referred to various cases on personal cost orders against office holders. And so I think it's quite an interesting case study on this subject. Starting first with the insolvency rules, because these make provision for the expenses in various insolvency processes. So as you can see there, I've put out the provisions for administration, for CVL, compulsory liquidation and bankruptcy. And they are practically the same in all instances. So taking administration, all fees, costs, charges and other expenses incurred in the course of the administration are to be treated as expenses of the administration. So the rules are completely clear that costs are to be treated as expenses of the particular insolvency process in question. However, the actual rules, it becomes slightly more nuanced than just what it would appear to be on the face of the rules, and need to look at the particular circumstances. So starting with the first scenario, which is where the office holder is the claimant. CPR parts 44 and 47, which relate to costs, apply to the costs of insolvency proceedings and the costs in connection with insolvency proceedings. That's by virtue of Rule 12.41. This means that the usual rules apply. The court has a discretion as to costs, but normal rule, Rule 44.2, is that costs will follow the event. And an office holder is not going to be given special treatment purely by virtue of their position as an office holder. This is an example of this, I think, is from the case of Walker and Walker, which was related to the issue of discontinuance. The liquidator brought claims against the directors of this company, but then realised at a later stage, even though it had been apparent beforehand, that recovery was going to be unlikely, and so the liquidator discontinued the claim. At the first instance, the judge had granted permission to discontinue the claim and had made no order as to costs, but this was overturned on appeal. And the court considered that it wouldn't be just to allow the liquidator to walk away from the proceedings, leaving the director, the defendant, simply to bear their own costs. So the office holder is not necessarily going to be given special treatment. I've just added at the bottom there a couple of rules to remind us all that in some instances the office holder will not be liable in any event, and it's particularly the case in relation to the official receiver. So the two rules I've given there, they relate to public examinations conducted by the official receiver. Still looking at where the office holder is the claimant, as we are all aware, there are different situations depending on the particular office holder role. So trustees in bankruptcy will litigate in their own name, whereas corporate insolvency practitioners, they might be litigating in their own name, or they might be litigating in the name of a company. In the first of those scenarios, where the company, where the insolvency practitioners will be litigating in the name of the company, then the company is litigating and the company will normally be liable. This is quite an important aspect to bear in mind if you're representing a defendant, because if the company has no assets or insufficient assets to meet an adverse costs order, then it could come to the end and the defendant is left with no way of recouping no way of recovering their costs. So one thing to bear in mind is consider making an application for security for costs. The other possibility is a non-party costs order. A non-party costs order can be made against the office holder. And I've referred to two cases there of Metalloy Supplies Limited versus against MA and Dolphin Keys Development and Mills. In Metalloy, it was held that it wasn't improper or unreasonable for an impecunious claimant to bring proceedings if they were proper and bona fide proceedings. There is a jurisdiction, though, to order a liquidator as a non-party to pay the cost personally. But in Metalloy, they said that it would only be in exceptional cases that the jurisdiction will be exercised. And it said that impropriety will be a necessary ingredient. They also said that caution is necessary in cases where an attempt is being made to render a non-party liable for costs, and this is particularly so in the case of a liquidator, given public policy considerations. The case of Dolphin Keys Development Limited and Mills, about 10 years later, that also dealt with non-party cost orders against office holders. In that case, it was held that impropriety or unreasonableness on the part of the office holder was not necessary, but still a non-party cost order will be exceptional, and that means outside the ordinary run of cases. The ultimate question, they said there, was whether in all the circumstances it is just to make the order. It's important to note that in both cases, the court referred to applications for security for costs and said that the availability of security for costs will be a relevant factor in the exercise of discretion. So the discretion to make a non-party cost order might be more readily exercised in favour of a successful litigant if security was not available at all or was inadequate. The other scenario is where an office holder is litigating in their own name. So this will be the case for trustees in bankruptcy and also liquidators, for example, for some claims. In those instances, the risk is that if an adverse cost order is made, there is insufficient assets in the estate to cover costs. The other issue is that the office holder may be deprived of their right to recoupment. I've referred to two cases there, BP Solicitors and Gabriel, and also Re Capital Films Limited in administration. BP Solicitors was a case about a trustee in bankruptcy. And in that case, Lord Sumption referred to the basic principles and said that the cost of satisfying the order is treated as an expense of performing his office, for which he assumes personal liability, but it is subject to the right of an indemnity against the assets if the expenses and liabilities were properly incurred. So there is this right to recoupment, but the litigation costs will have to be properly incurred. The other case I referred to is Re Capital Films Limited and Administration. So this clearly was a case of administration. And there the judge discussed the court's discretion to deprive an office holder of the right to recoupment and looked at the circumstances when this might be likely. In that case, the circumstances included misconduct, serious mistake, or where it might be unjust for other reasons to permit recoupment. I'm going to return to Re Capital Films Limited later when I consider Nimat Halal. So where does this leave legal advisors when they're advising insolvency practitioners? So the things to consider are third-party funding, assignment of claims to companies specialising in funding litigation, conditional fee agreements, after the event insurance, and indemnities for creditors. These are all ways that insolvency practitioners can protect themselves against serious cost orders. The other scenario is where an office holder is a defendant to the claim. So the insolvency rules provide here, this is rule 12.47, that where an office holder, the adjudicator, or the official receiver is made a party to any proceedings on the application of another party to the proceedings, the office holder, the adjudicator, or official receiver is not to be personally liable for the costs unless the court otherwise directs. So here the office holder has not brought the claim themselves, but they've made a party, so why should they have to pay the costs? However, the court can direct otherwise, and this is something we're going to consider more when we look at Nimat Halal food. So coming on to Nimat Halal food. In this case, the company, which was called Tariq Halal Meat, had entered into administration, and the administrator who was subsequently appointed began investigating claims against the company. The administrator rejected two proofs of debt that were submitted by Nimat Halal Food and another company called Nimat Halal Meat Limited. And the applicants in this case, who were Nimat Halal Food and Nimat Halal Meat, applied pursuant to Rule 14.8 to appeal against the decisions of the administrator to reject their proofs of debt. This came to trial, and Judge Briggs allowed the appeal and found that the sums, at least in the case of one of the proofs of debt, was properly due. And following that judgment, the applicants sought a personal cost order against the administrator. Now, I think this is a useful case because it provides guidance on the approach of the court on an application for a personal cost order under Rule 14.9. That's specifically about appeals from proofs of debt, rejection of proofs of debt, but it also looks at the case law on personal cost orders against office holders in a broader range of circumstances. So it provides a useful examination of the case law. When Judge Briggs gave his judgment, he started by looking at Rule 12.47. So that's the rule that we looked at just 2 slides ago, that normally an office holder is not to be personally liable where they're made a defendant or a respondent to the application. Judge Briggs then proceeded to focus in on Rule 14.9, which is specifically about costs where there's been an appeal from rejection of a proof of debt. And Rule 14.9 provides that an office holder other than the official receiver is not personally liable for costs incurred by any person in respect of an application under Rule 14.8 unless the court orders otherwise. So if you note, that's quite similar wording here, unless the court orders otherwise, to Rule 12.47, unless the court otherwise directs. Judge Briggs then proceeded to consider various cases which relate to personal cost orders against office holders. So the first case that he looked at is re Silver Valley Mines. So we're going back well over a century ago. And in that case, the liquidator had applied to have a claim of a creditor disallowed. In that case, the court decided that although the liquidator had a right to recoupment, the liquidator's application was considered a blunder and altogether improper and wrong. As a result, a personal cost order was made. The next case, moving back a century forward, is Capital Films Limited. And here the administrators had entered into a conditional sale contract for the sale of all the assets of the company and sought permission to include in the sale assets of the company which were subject to fixed charges as if they were not subject to that security. However, the administrators eventually decided no longer to pursue the application. The judge held that the administrator's application, which was pursuant to paragraph 71 of Schedule B1, was irrational and misconceived. And it was held that the conduct was in the same category as the blunder and the serious mistake as we saw in Silver Valley Mines. And so it would be unjust to permit recoupment. So a personal cost order was made. The next case was Coin and DRC Distribution Limited. Here, this was an appeal by the administrators against an order that they pay the creditors' costs in the creditors' application to remove the administrators. It was held that because the creditors' application had been made redundant by the administrators applying to terminate their own appointment, but nonetheless, it was held that the creditors' application was properly founded and would have succeeded. So a personal cost order was made. The next case is Promontoria Chestnut Limited and Craig. Here, a secured creditor had sought a declaration that the administrators had exercised their discretion unreasonably by removing or requiring receivers to vacate office, and they'd been appointed by the applicant. It was held in this case that there was a good reason to make an order that was otherwise, because the proceedings had been necessitated by the administrator's unreasonable and peremptory decision to require the receivers to stand down. And so a personal cost order again was made. Finally, the Judge Briggs looked at Reburn Group Limited. In this case, the creditors had applied for a personal cost order against the liquidator on their appeal against his rejection of a proof of debt. And here the court accepted that if an office holder is found to act for his personal advantage, this ought to lead to a cost order. But the court also said that it should not direct an order otherwise, so a personal cost order, save in a special case where there was a good reason to do so. And in this case, no personal cost order was made. So turning back to what Judge Briggs decided next. So he then proceeded, after reviewing all those cases, to give guidance on the cost rules under Rule 14.9. The starting point is that an office holder will not generally be liable, and something more is required to obtain a personal cost order against them, and that will relate to the office holder's conduct. It is always going to depend on the circumstances of the case, so it's very, very fact specific. But a mere mistake normally will not be enough, and acting in a neutral manner will not be enough, or is likely not to be enough. But on the other hand, if the office holder is acting for personal advantage, that is very likely to lead to a personal cost order. Judge Briggs characterised that sort of instance of acting for personal advantage as being a special case or a good reason, and it's very likely to be characterised as irrational or unreasonable conduct. So that's what we're sort of looking for here to justify a personal cost order is irrational, unreasonable conduct or a good reason, a special case. The Judge Briggs also took into account the particular duties imposed on the office holder to investigate the proof of debt. And I've set out those duties there that were taken into account. Finally, after Judge Briggs considered the facts in this case, he emphasised that the matter had to be looked at in the round. So the applicant cannot cherry pick incidents. It's about taking everything holistically and considering it that way. In this particular case, the administrators had relied on the paper trail that had been left by the company, but at trial, on cross-examination, it turned out that the arrangement didn't actually operate in accordance with the written terms. And this was quite significant for Judge Briggs. He held that the administrator had acted appropriately in integrity and had been entitled to rely on the paper trail. He also noted that the administrator had adopted a neutral position at the hearing. In the circumstances, he looked at it in the round and rejected cherry-picking incidents. He therefore declined to make a personal cost order. This case is obviously very useful for any application for costs against an office holder under Rule 14.9. But I believe that it also is more generally useful and provides helpful guidance on where an office holder is likely to be deprived of their right of recoupment and where personal cost orders might be made under Rule 12.47. The case law that was referred to relates to a number of different scenarios, but it's clear that it has to be a special case and there has to be a good reason. And a mere mistake is not enough. It will have to be irrational or unreasonable conduct. It's also clear that the duties of the office holder in the particular circumstances are likely to be important. And ultimately, it needs to be looked at in the round, depending on all the circumstances of the case, rather than isolated incidents. So that's my take on Nimat Halal and what we can take away more generally about cost orders, personal cost orders against office holders. I hope you found that useful. And now I'm going to turn over to Katie, who's going to talk about adjournments.
Adjourning the bankruptcy petition. I think many of us have found ourselves in a situation where we've been instructed to seek yet another adjournment for a debtor seeking time to pay, or we've been instructed in a case where we think it's a straightforward bankruptcy petition hearing, and then we get to court and we're surprised with an adjournment application by the debtor. So what we're going to do today is just look at the basis upon which a court can grant an adjournment in those circumstances and consider some of the recent related authorities along the way. So turning to the next slide then. So I think just to start, let's have a recap as to when the court can make a bankruptcy order. So first of all, obviously you need the creditor's petition to be in respect of one or more qualifying debts. And by qualifying debts, I'm referring to the provisions in the statutes, which are owed by the debtor to the petitioning creditor. So on the slide there, I've included section 267, 1 to 2, which provides that that debt will need to be the same or more than the bankruptcy threshold. It will need to be for a liquidated sum payable immediately or at some certain date in the future, and it will also need to be unsecured. We know that the debtor will need to appear to be either unable to pay or have no reasonable prospect of being able to pay. And in bankruptcy proceedings, of course, that means that either we've got a statutory demand and 3 weeks have elapsed since that statutory demand was served and it hasn't been paid, or we have a judgment debt and an execution or other process has been instigated to enforce that debt and the money still hasn't been forthcoming. The final thing we require is that there is no outstanding application to set aside a statutory demand in respect of the debt or debts in issue. And 2711 provides that the court shall not make a bankruptcy order in respect of a debt that has been paid or secured. And similarly, it can only make a bankruptcy order where the debt which the debtor has no reasonable prospect of being able to pay when it falls due. So you've got two different options there. Turning again to the next slide, I think there's a slight delay, just bear with me. Here we are. So if the court has those statutory conditions before it fulfilled, then the position vis-a-vis the bankrupt, or sorry, the debtor, that should read, is that the petitioning creditor is entitled to a bankruptcy order. But that isn't the end of the story. And as we know, it doesn't necessarily mean that a bankruptcy order will be made on that hearing date. So it could be the case that the debtor says that there's been an unreasonable refusal to accept a security that's been offered. That's section 2713. Or it may appear that the petition itself is an abusive process, contrary to the class remedy nature of bankruptcy proceedings, such that a bankruptcy order won't be made. In very exceptional cases, a court may find that a bankruptcy order would actually serve no purpose whatsoever. So that's a case where the debtor seemingly has no assets, and so a bankruptcy order would just be a cost-generating exercise. Now, those arguments are frequently raised in the courts, but very infrequently won. Another example where a bankruptcy order may not be made is if other creditors oppose it. So where a petitioning creditor seeks the order, but supporting creditors come out of the work and for whatever reason don't want the order to be made. And we'll be looking at that scenario a bit later. But of course, it might be the case that the order is neither made nor the petition refused, and the court instead decides to adjourn the petition. Now, a petition can be adjourned for various reasons. It may be that the petition needs to be amended. It may be that there's another creditor that needs to be substituted or further evidence is required. But the circumstance we're going to look at today is where a debtor is seeking time to pay. So what then are the procedural, what is the procedural basis upon which an adjournment application should be made and the adjournment ordered? So the procedural rule is 3.2b of the CPR. That's imported into insolvency proceedings by virtue of rule 12.1. And the court's approach to adjournment applications, specifically in bankruptcy proceedings, is different to the usual considerations that we'd see in general civil proceedings. And a specific test has been evolved in light of the very nature of bankruptcy proceedings. And we need to consider the background to understand why we have this test. So the background to that test is effectively twofold. Firstly, insolvency proceedings are class actions. So the purpose of them is to secure a distribution for the debtor's creditors to distribute the preserved assets for an independent person to be appointed and ensure that so far as the unsecured creditors are concerned, those assets are distributed pari passu. So it's not a mere debt collection process on the part of the petitioning creditor. Another key consideration which informs why we have this test is that if a debtor is ultimately made bankrupt, from the date upon which the petition is presented until that bankruptcy order, in the interim, any disposition that is made, so any payment that is made by the debtor, will be a void disposition by virtue of section 284 of the Insolvency Act. So with these points in mind, it obviously would be potentially prejudicial to creditors if a petition was made and just there were various delays until the order was forthcoming. So on that basis, the court has decided that to grant adjournments where the debtor asks for time to pay, it will need to be satisfied that there is credible evidence that there's a reasonable prospect that the debtor can pay within a reasonable time. Now, in the case of Edgington and Secon, the principle was summarised there that it was the petition debt that needed to be paid. And as we have seen very recently in the case of Robertson and Wojakovski, that principle has now been clarified. So just moving to the next slide. The facts of this case can be fairly simply stated. Mrs. Robertson and Mr. Wojakovski were in fairly hotly contested litigation. there was an unfair prejudice position, a share transfer action, and a derivative claim. And the results of these actions meant that Mr. Wojakovski was subject to a cost order. Now, Mr. Wojakovski was served with a statutory demand in respect of that cost order, and then found himself before Mr. Justice Zaccaroli on his bankruptcy petition hearing. The petition debt itself was only worth 135,000 odd, but supporting creditors appeared to the tune of £16 million. Mr. Wojakovski had to accept that he had no defence whatsoever to the bankruptcy petition. What he argued is that he could rely on the court's jurisdiction to adjourn the bankruptcy petition on the basis that he had a reasonable prospect to pay the petition debt, so the 135,000. It appears as if he did not dispute the supporting creditors' debts either, but he had to accept that he didn't have a reasonable prospect of paying the 16 million odd. So the judge had to decide which debt he had to show ability to pay. And interestingly, there was no authority on this precise point. So the judge considered the arguments before him, and for the reasons on that slide and the one that follows, he decided that actually the debtor needs to show he can pay the supporting creditors as well. Now, as you'll see, he emphasised that bankruptcy is a class remedy, and that is shown by the fact that the usual course is a creditor will give notice of intention to support the petition. That's, of course, if the creditor is aware of the petition, gazetting, advertisement not being a requirement in bankruptcy proceedings, as we'll see shortly, rather than present its own petition. And what comes with that right is also a right to be substituted as a petitioner. So that demonstrates the class nature of the action. And with that in mind, in circumstances where the debtor had already accepted that he wouldn't be able to pay these debts, if an adjournment was granted such that he would then pay the petitioning creditor's debt and a bankruptcy order was subsequently made, what we would have is a void disposition in the interim, which again would be contrary to the nature of bankruptcy. So you'd be forgiven for thinking that this isn't a groundbreaking decision. It makes complete sense as to why, if one's seeking to adjourn, that they should also show they can pay other undisputed debts as well. But it does provide clarity. And what this judgment does is avoid the repeated adjournments and applications for substitution that we may otherwise see in proceedings. I'd also query what impact this could have to the actual hearing itself, if there are other creditors potentially that are able to come out of the woodwork. It might be that a petitioner thinks it's prudent to consider if there are any other creditors that may be able to support his or her petition. Similarly, there may be questions around any obligations on the debtor's part to disclose any other creditors that he may have at that hearing. So moving on then from that decision to another consideration, what if other creditors oppose the bankruptcy order, the making of the bankruptcy order? Now, this was exactly the case in Glenn Maud and Digby Rogers cases. In the petitioning creditor sought a bankruptcy order, but the other creditors did not. And Mr. Justice Snowden, again, with reference to the collective nature of bankruptcy, said this: where creditors oppose the making of an order, the court must come to a conclusion in its discretion after considering the arguments of the creditors in support of and opposing their petition. But how then does this relate to an application on the debtor's part for time to pay? Well, quite obviously, if you have other creditors also not wanting a bankruptcy order to be made, then that is going to bolster any application for time to pay. But what has to be emphasised is that the court's power to consider the creditor's interest in that regard is distinct from the discretion it exercises when it is deciding whether to adjourn for time to pay. And that point was made by, again, Mr. Justice Snowden in Maud. he said that this type of discretionary decision, that is the time to pay adjournment application, is not a substitute for the consideration by the court of the separate question of the views of the members of the class in a case in which the petition is opposed by other creditors. The majority of creditors may consider that their prospects of getting paid are better if no bankruptcy order is made at all. That decision is theirs to make and is not circumscribed by considerations as to whether payments will be made within a reasonable time. It is also a question in which the debtor has no voice. So how then is the court likely to approach an adjournment application in this context? Well, one would expect that the court would first of all consider if the statutory conditions that we've referred to at the beginning are satisfied, if there's any other reason why a bankruptcy order should not be made, and to consider then the interests of the creditors, and as a distinct consideration to then consider whether an adjournment should be granted. Just going on to the next slide again. So a question then that flows from that is, how are we to weight creditors' interests? They're obviously central to the issue of whether an adjournment is going to be granted, but also whether a bankruptcy order is going to be made at all. Lord Justice Upjohn addressed this in Re P&J McRae Limited and said as follows: weight is to be given to those wishes in determining whether a winding up order ought to be made. I should pause there. This case obviously was in the context of corporate insolvency, but it has subsequently been applied on numerous occasions in the bankruptcy context. So the rationale applies equally to this personal insolvency scenario. So whether a winding up order ought to be made varies according to the number and value of the creditors expressing wishes and the nature and quality of their debts. I certainly do not accept for one moment the proposition that it is merely a matter of counting heads, and that a majority of 51% opposing a petition will outweigh the views of the 49% who support the petition. In such a case, where the wishes of the creditors are so evenly balanced, the weight to be given to the majority view is obviously negligible. And he went on to say that there may be an issue as to the quality of the creditors as well. The circumstances may be such that the court is rightly suspicious of the opposing creditors and the motives which are actuating them. So an example that comes to mind is if supporting creditors appear and they all appear to be associates of the debtor, the court may be suspicious or more suspicious of those supporting creditors. In such a case, the court may desire to have evidence before it of their reasons for opposing. So again, another reason why an adjournment might be granted in the bankruptcy petition context. And as pithily put by Mr. Richard Sykes, QC, and Lee Estates, it is for the court to decide, as a matter of judicial discretion, what weight to attribute to the voices on each side of the contest. Adjournment applications should not be approached lightly. There is no guarantee that an adjournment will be granted, even if it is the first hearing. So whether you're for the petitioning creditor or the debtor, you'll need to critically consider the evidence that's in support of this application. And of course, that evidence will need to show a reasonable prospect of paying all the supporting creditors, that is the undisputed creditors, within a reasonable time. Now, it's interesting to consider the facts in Wojakovski. In that case, Mr. Justice Zaccaroli effectively pulled apart the evidence that was put forward by him. He sought to argue that he would be able to realise or he was entitled to some distributions from a company of which he was a 50% shareholder, and it was the other shareholders' fault as to why he hadn't realised those distributions sooner. So there was already issues with that argument as to the timing upon which he might receive payments. But the judge didn't hold back and looked at the documentation and considered that the intercompany debts hadn't been exaggerated to the extent that Mr. Wojakovski said they had. He found that the valuation that had been placed on a key asset, a hotel, couldn't be relied upon. And he also found that in light of the way in which the shareholders had been dealing with the companies. You'll recall that in this case, there have been a derivative claim, share transfer action and an unfair prejudice petition in the background. In light of that, he seemed to think there could be tax liabilities, which hadn't been accounted for yet. So in those circumstances, that allegation that he would be able to realise those funds really wasn't met. He also argued that he had artwork at his disposal to be worth about £2.5 million, and he referred to an insurance policy by a reputable insurer as evidence of that. Again, that evidence was critically considered, and the judge determined that there wasn't actually any documentary evidence that he owned that artwork. The correspondence from his own solicitors suggested that he didn't, or certainly it wasn't available for his use at that time. And also what it transpired, as transpired in that case, was that even if he did have this artwork, it was wholly undermined by the fact that he hadn't realised those assets earlier on in the litigation. So the point to take away there is be prepared for your evidence to be properly and critically considered. Another consideration is to be wary of creditors coming out of the woodwork. Of course, that phrase is, negative connotations, but it may be that creditors will be able to support your application as well. If you have creditors that think that a bankruptcy order would not be in their interest and you're the debtor, you may wish to have those at your side to bolster your adjournment application. With that in mind, one needs to put their mind to what weight can be afforded to those creditors. So, as I said, if they are associates of the debtor, depending on your position, they may have limited or more weight to your argument. And finally, my last piece of advice would be give notice to the petitioner and the court of your adjournment application as early as possible. And do not find yourself in a situation as Mr. Edgington did in Edgington and Secorn, where you're effectively seeking an adjournment application at the last possible moment. In that case, he asked the court to adjourn the bankruptcy petition when the judge had already started to give his decision. So there you have it. That's my my take on some of the recent authorities in this context, and a bit of advice for you. Thank you, everyone.